The following program is a Town of Colonie television production of the William K. Sanford Town Library.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our legal system, our justice system, and how they intersect with the citizens of the town of Colonie. Today we are truly fortunate to have as our guest Attorney Timothy J. O'Connor. Mr. O'Connor has spent over 30 years practicing in the area of financial fraud. He's also a lifelong resident of the town of Colonie and maintains his office to practice right here in the town of Colonie. And Tim, welcome and thank you for joining me today.
Thank you, Judge. It's an honor
Well,
to be here.
you know, we go back as childhood friends, and both were at Shaker High School at the same time, and your brother Pat was in my class.
Blue Bison.
At Shaker, and so much has happened since then, and your professional career has just taken off over the last 30 years. You've been hands-on in the world of financial fraud. And for many of our residents in the town who have brokerage accounts or investments with others, they often and typically will have a variety of questions about whether they've been treated correctly or whether their product line that they've invested in is one that they should be in, or whether it's actually one that provides too much risk for them. And you ultimately have found your way into the courthouse, not only federally, but state court as well, and typically in arbitration matters on broker cases as well, and their treatment or poor treatment of the customer. And tell me how you got involved in this niche practice.
Well, Judge, my first case I filed back in 1985. I was representing a retired janitor who had his retirement lump sum rollover invested in index options, a very speculative investment within the stock market. And lo and behold, he lost the lion's share of his retirement because the broker and the brokerage firm in question there had heavily traded the account in the index options, and the market turned, and 70 to 80% of the account evaporated overnight. And so back in 1985, the remedy for a victimized investor would be to file a complaint in federal court. So that's what we did. We filed a complaint in federal court against the brokerage firm. And while the case was pending, 2 years later, in 1987, the Supreme Court came down with a case that said, if you're a victimized investor dealing with a brokerage firm, you have to bring your disputes to arbitration. You can no longer go to court. So from 1987 onward, court cases were no longer a viable option for most retail investors who have brokerage account statements with arbitration agreements. So from there, obviously, it started my career, if you want to say that, in the arbitration arena because of the Supreme Court ruling. And since then, this has been the sole forum for, I would say, 95% of all investment-related cases have to be arbitrated. There's certain cases that you could still go to court on in the insurance arena, for example. If it's an insurance product, oftentimes you can go to court. But if it's a securities case involving investment securities with a brokerage firm, 99.9% of the time, you will be required to bring that claim in an arbitration arena. And there is one main arena now in the United States for that. It's the Financial Industry Regulatory Authority. The acronym is FINRA, F-I-N-R-A. It used to be called the NASD. And in fact, before that, there were two separate facilities, the New York Stock Exchange and the NASD. They merged their facilities 7 years ago, and the new acronym is FINRA, the Financial Industry Regulatory Authority. And they maintain offices in New York City. But when these cases go to hearing, they have different sites in New York State where hearings are held, including Albany, New York.
And I just saw an advertisement on our Albany County Bar Association website bringing attention, I believe it was that website that brought attention to the fact that FINRA is looking for hearing officers.
We are, yeah. The FINRA is looking for lawyers, accountants, any people from any profession, retired teachers, anybody who feels that they have the wherewithal. There's a training process.
Right.
And that's a separate, it's run by FINRA, not me, I'm a private practitioner.
Right.
But what they do is you take a training course and you can become an arbitrator and you can sit on cases and decide cases, and it's a training process that they have.
All right.
And if you're from the Albany area, they do have a training session a couple times a year in the Albany area, or you could contact FINRA directly at their New York City offices. But the new era of arbitrators is a very broad and diverse pool of arbitrators in this day and age. 30 years ago, it was a very small pool, and quite frankly, there were very few public advocates. There were very few non-industry people on these panels. In fact, the first cases I had, by and large, it was mostly in the investment industry, comprised the arbitrators.
Did it give you the impression that possibly the deck was stacked?
Well, there was that impression. And what happened was, in the late 90s, in the early part of the last decade, there were some initiatives in Congress whereby the arbitration boards in FINRA and NASD were required to pursue some outreach issues, whereby they would encompass people from all walks of life: sociologists, psychologists, retired doctors. The common person would be recruited and sit on these panels. In fact, now there's an option when you file an arbitration claim that you can pick a panel which has all public members and no one from prior affiliation with the securities industry.
Right.
So it's gotten to be a more fair and balanced configuration.
Well, tell me this, Tim. No doubt, based on the length and breadth of your practice, that routinely you receive inquiries at your office from people who believe they might have been harmed by a broker. But how many of those actually will you end up finding that it makes sense to proceed to arbitration?
Well, that's a good point, Judge, and I think you probably see the same thing in court, in your small claims court. A lot of people think they've been victimized or they've been wronged, and we do live in a litigious society. But I would say 4 out of 5 people who think they've been wronged, oftentimes what you're really looking at is a downturn in the markets. Just because you've lost money in the financial markets does not mean you've been victimized.
Right.
And what we look for is affirmative acts of wrongdoing, affirmative acts of mismanagement, fraudulent activity, excessive trading, forgeries, theft of monies, for example, or the generation of commissions for the sole purpose of lining the broker's pocket versus trading activity designed to benefit the investor.
Right. Now, oftentimes, and we've all even seen articles in the business section of various newspapers here in the Capital Region about very notorious cases.
Well, we've had
where people have lost a tremendous amount of money.
Yes, I know. We've had a number of problems locally. There's been a spate of firms that have come and gone that have sold improper investments to mom and pop.
Right.
And a lot of the problems you'll see in this arena is broker-dealers or brokerage firms or financial advisors, whichever hat they're wearing at the time, selling illiquid, speculative, and improper investments. A lot of retirees in this area, for example, have been pitched what's called private placements, which is a illiquid investment, which means you can't get out of it. You can't sell it overnight. And what happens is with these illiquid investments, you're buying into, say, a shopping mall, or you're buying into an operating business of some kind, or you're purchasing a piece of an oil well or a drilling project or a gas project. And private placements, by and large, are not meant for mom and pop. Private placements are subject to strict rules, the accredited investor rule, which means you have to have income of $200,000 a year for the past 2 years, or a net worth of at least $1 million exclusive of your private residence if you're going to get involved in a private placement investment. And what happened locally is there were several firms, one firm in particular, that sold over $100 million of these private placement investments. And lo and behold, as it turns out, they were certainly self-dealing. In fact, some of the principals now are serving time.
Right.
And unfortunately for a lot of these investors, there really wasn't any meaningful insurance, and they're really out of luck. And so, this is one of the things we've seen.
Well, tell me this, and you've mentioned some non-liquid vehicles, and there are other investment vehicles that are pitched to people in order to have them invest in them. Is the reason why, one of the reasons why they're pitching these offline or risky vehicles is that the broker gets a higher commission if they make that sale?
That's right. There's a lot of, in fact, a lot of household name insurance and financial firms are selling products such as variable annuities. Variable annuities is an insurance hybrid securities product, which has some insurance features and some securities features. But a product like that, for example, carries a 7-8% commission. So if you put $500,000 into a variable annuity, right out of the gate, you're paying a $35,000 or $40,000 commission just to buy that product.
Right.
Whereas if you put $500,000 into, say, a no-load fund, you wouldn't have that charge. So a lot of these speculative, illiquid, or types of investments carry higher commissions, and which leads to the motivation for the brokers to sell them.
Are there typical earmarks of a case that you will represent somebody on? What do you look for to see whether it's a case that's worthy of the arbitration procedure?
Well, we look at a case of what we like to think is true victimization. Oftentimes, in our classic profile would be maybe a fairly recent retiree, maybe someone who was in their 60s, maybe someone who might not have an advanced education, who had a lump sum of monies which was preyed upon or put into inappropriate diversification. Maybe it's concentrated in a single stock or a single investment, or like a REIT, like a real estate investment trusts. If you look in the phone book and you look on Google, there's thousands of people willing to sell you products, and right here in Colonie, and you got to figure out what their motivation is. Yeah, that's a typical profile as a recent retiree who has a sum of money and wants to know what to do with it. And for example, there's been a number of firms locally, private firms, that when their employees retire, they're offered the option of a fixed annuity or a rollover of a retirement account. For example, NIMO, now National Grid, they would offer their retirees a rollover. They could just take the money and give it to somebody else.
Sure.
Or they could leave it with NIMO's administrators, and they would have a third-party annuity pay you a guaranteed stream of income for the rest of your life. A lot of retirees, unfortunately, got hooked up with, they took a rollover, and they got invested with private investment firms who might not have been looking out for the best financial interests, and there have been a lot of losses sustained. So we see a lot of that. Other things we've seen locally is there's a new trend now where a lot of financial advisors and stockbrokers are leaving their firms. These are individuals, professionals with household name financial firms. They're leaving those firms to open up their own operations.
All right.
But what you have to ask yourself is who stands behind them? A lot of these guys don't have any insurance. They don't have any backup. They have no capital. And if something happens to your account, what's your recourse? And that's a trend now, is where because of the discount brokerage firms, a lot of brokers are leaving full-service firms, domiciling accounts with like discount brokers, Schwab or TD or Ameritrade or one of these firms, and they're just trading the accounts without any meaningful supervision, without any compliance, without any oversight, and that can lead to problems as well.
Do you think there's comfort for our residents engaging in financial transactions like brokerage transactions with national firms, or that doesn't necessarily provide any comfort?
Well, just because you're doing business with a national firm doesn't mean you're safe.
Right.
And as you know, there have been a number of multi-million-dollar fraud cases involving household brokerage firms that were involved with analyst fraud, variable annuity fraud, securities analyst fraud, and stock trading related fraud and manipulation. So just because you're dealing with what you think is a household name doesn't mean you're necessarily safe.
Tell me this: when you've made a determination that a client has a case worthy of moving forward, that you find in your own file that there appears to be victimization supporting a proceeding, how does the process work? What do you do then?
Well, by and large, it's probably going to have to go through arbitration if it involves a securities product. Stocks, bonds, mutual funds with a brokerage firm, you'll have to go to arbitration. And over 99% of the arbitrations in this country have to be filed with the Financial Industry Regulatory Authority, FINRA, as I talked about earlier.
Right.
And before you file the case, you have to put it together. You have to figure out what happened. You have to calculate the damages. You have to analyze the activity. And a lot of times, people don't know what happened, and it takes someone who's done it before to put the pieces of the puzzle together and tell a story as to what happened. FINRA has a rule that says if a client's been victimized, if you're a victimized investor, they give you a 6-year look-back period. In other words, any trading activity only within a 6-year eligibility period can be considered. So if something happened to you 10 years ago, it might be difficult to pursue that claim.
Kind of like a statute of limitations.
It's in a way, it's not quite the same thing, but it's close.
Okay.
It's close. But to put a case together, we engage in some forensics. We review the trading activity. And what we will do is prepare schedules of trading activity. We'll summarize the trades. We'll measure the amount of velocity, the turnover ratios. We'll measure the commissions paid. We'll measure the losses. If there was margin interest charges, we'll measure those. If there were concentration issues, or too much in one stock, or too much of one thing, we'll do all those metrics and try to measure them out so that when they're submitted for arbitration, the arbitrators can look at the case and decide whether or not it's a viable case, whether it's, and so you really, when you file a claim, you're telling a story. And it's got to be credible, it's got to be supported by the law, and it's got to be supported by the numbers. Arbitrators have free authority to make decisions, broad authority. In fact, it's very difficult to appeal an arbitration decision.
Right.
In fact, arbitrators are also exhorted in their training process to consider the concept of equity, which is what you're familiar with. I know when you decide a case in Colonie Court here, in small claims, equity means what's fair. So we talk about different claims in cases. We talk about, is it a fraud claim? Is it a breach of contract claim? Is it a claim under the federal securities laws? Is it a claim under some statute? Those are all common law or statutory claims. But the other big picture that's often considered is equity. Like you consider equity in your small claims case. Equity means the arbitrators can even assess a case and hear the testimony of both sides and make a decision. And the decisions they rendered are not required to particularize their rationale. In fact, the decision in an arbitration case generally is only required to say whether an award is given or not. They're not required to give a detailed explanation of their thought process.
Are arbitrators required to create a findings of fact?
No, they're not.
Right.
Although there is an option, if both sides to a case agree, you can agree and ask that the panel prepare a reasoned decision.
All right.
Most people don't want to do that because what you're doing is you're opening up a decision to appeal. And the bases to appeal a decision in arbitration are very very, very, very strenuous. I mean,
Right.
you have to show fraud.
Yeah, you bet.
You have to show the arbitrators were
Right.
fraudulent or
Right.
took a bribe or something, or
Yeah.
really did something bad, and
Was it more than arbitrary and capricious?
yeah, arbitrary and capricious is a state court standard. You're
Okay.
right. Good point. And it has to be really, really flagrant to upset an arbitration award. But keep in mind, the arbitration process was put in place by the securities industry in the first place. They didn't want to go to court.
Right.
And it was the securities industry back in 1987 when they went to the Supreme Court that argued successfully that no longer could customers have a jury trial.
All right.
No longer could you go to court. You got to go to arbitration. So that's how the rules were set up, and that's the forum that most of these cases are decided in. Now, one thing I didn't mention is if it's an insurance product, let's say you have a problem with a whole life policy,
Right.
and we've seen problems there. Let's say you have a several $100,000 whole life policy. We've seen problems with insurance products where brokers will take an insurance policy and strip away the cash value, strip away the whole life cash value of a whole life policy to get you into a different insurance product or a different type of annuity or a different type of life insurance policy. Those cases are oftentimes, your sole remedy would be in the court system, and it would be a whole different arena. You'd be with judges and juries and depositions and appeals and all these types of things. So that's the other half of the coin, if you will. You've got securities products, which are generally go to arbitration, and you've got whole life or insurance type products, which generally go to court.
Do you find when you file for arbitration on behalf of a client that sometimes there's a settlement before arbitration? Just like in litigation, sometimes when the action starts, sometimes there's a settlement outside of judicial intervention.
That's a very good question, Judge. And just like you send people out to the hallway, right, in Colonie Court here, don't you send them out and say, well, can't you guys figure it out? If you can't, we'll have a trial in half an hour. Statistically, in the FINRA arbitrations, approximately 85% of all claims filed are settled before they go to hearing. So that's sizable. Not only that, but FINRA in the past 5 years has really ramped up its mediation department. And mediation is a process within the arbitration arena, if you will. It's a dual track process whereby when your arbitration case is pending at FINRA, you are also invited to say, look, you filed an arbitration claim and you're entitled to have a hearing, but before you go to a hearing, we will offer you the opportunity to have a mediation as well.
Right.
And a mediation is where you would sit down with a neutral mediator and spend a day or two or a week, whatever it would take, to see if the case could be resolved. And mediation has seen an explosive growth in activity, and it's a very productive way. In fact, you had mentioned that the Albany County Bar Association is looking for arbitrators to serve with FINRA. FINRA is also looking for mediators. And that's a different skill set, different training process as well. So mediation and or settlements comprise 85% plus or minus of all the cases filed at FINRA. And then of the cases that go to hearing, you win some, you lose some. Sometimes they split the baby. You just never know. It depends on the panel.
So sometimes there's no cause. It's like
sometimes.
Nope. Yeah, okay.
And these cases are, if the case involves a monetary loss in excess of $100,000, you get 3 arbitrators. So what you'll need is 2 out of 3 to agree if there's going to be an award or there's going to be a dismissal. Whereas cases of $100,000 or less, generally speaking, you get 1 arbitrator.
All right.
So which can be a little more concentrated. You got to appeal to 1 person as opposed to 3.
Yeah, well, every fact pattern is different. How long would is there a typical arbitration time period?
Yeah, statistically it's about a year, give or take, depending upon the complexity of the case. When you file a claim in arbitration, within a month after filing it, they have a scheduling conference. And what that means is they schedule the time frames leading up to the hearing itself. And that would include the time frames for each side has to exchange documents, The investor has to produce their personal financial records. The brokerage firm has to produce their records of supervising their broker. They have to produce internal emails. They have to produce documents that are related to the transactions. That can take 6, 7, 8, 9,
Like
10
a
months.
discovery process.
A discovery process.
Right.
And which is something to consider. If you're going to file an arbitration claim,
Right.
you got to be ready to lay bare your personal financial history, tax returns, brokerage accounts, insurance account statements, retirement accounts.
Right.
So it takes a lot of time, and it can be a very time-consuming process. But if you've got a viable claim, it's worth the effort.
Well, no doubt you've served your clients well over the past 30-plus years. Tim, how would your office be compensated in a case like that for the efforts that you made on behalf of your client?
Well, generally speaking, most people who've been victimized don't have the upfront monies to pay for a lawyer. And most of the cases we take in this arena are on a contingency fee basis,
All right.
which means we don't charge a legal fee unless we have a settlement or get you an award.
Right.
Okay. Now, there are some costs, and clients take care of those costs in the process. But once you get an award, if you get an award, there's a process after that whereby the arbitration award has to be confirmed in court. And that can be confirmed in state court or federal court, depending on the type of case and depending upon whether you got an out-of-state client or out-of-state firm. If there's diversity and there's a dollar amount in question, you can go to federal court. If it's a state court claim involving state company, a New York State company, a New York State investor, you can get your award confirmed in state court, Supreme Court, Albany County Supreme Court, for example.
Just to file an index number and a petition.
Index number petition, that's right.
RJI?
Exactly.
Okay.
RJI.
Request for judicial intervention.
That's right. And you got to pay your fee for that, yeah.
Now, you told us earlier that really the arbitration process in these matters was really the creature of the financial industry. Do you think now, though, as it's gone on for the past 25 years or so, that it actually makes sense for the investor also?
It's gotten more fair.
Okay.
It's gotten more fair. And, when you have an arbitration case, you are afforded the opportunity to review the potential arbitrators. There's a process whereby both sides get to look at a list of potential arbitrators and strike certain arbitrators and rank the rest of them in order.
Right.
For example, in a 3-panel case, you're given 3 separate lists with 10 arbitrators each on each list.
All right.
And on each list, you can strike 4 of the 10, and the remaining 6 you rank from 1 to 6. So you do have some ability to control who you're going to get. And also, now in the process, when you go to select an arbitrator or decide whether you want to rank an arbitrator, you also have access to their prior decisions. So you can see whether an arbitrator has a history
Right.
of being fair. Okay.
Right.
On occasion, when we're asked to rank arbitrators, I'll go look at the arbitrators' histories, and I'll see an arbitrator I've seen arbitrators who've had 15 decisions, and they've never ruled in favor of the investor.
Okay.
If I'm representing an investor,
Right.
I might not want to have that arbitrator.
Well, it's like jury selection.
Jury
in
selection,
many ways.
it is.
It's a voir dire, and
Yeah.
you have an option to at least have some input on the selection process, but not being able to personally select the exact
Not the
arbitrator.
exact one.
Right.
But it's gotten more fair.
Right.
And the good thing about the arbitration process is, in court, you'd have stenographer fees, okay?
Right.
Nothing against stenographers, but it's going to cost you $1,000 a day, $2,000 a day. And you're going to have appellate fees to file appeals and briefs, which can be $5,000 or $10,000. And there's other costs in court cases. You can easily spend $20,000 in stenographic fees, in appellate fees, printing fees that, you don't have that in arbitration. So it's a streamlined process because there's no depositions and you're generally not filing appeals. And it's generally a quicker process. Court cases can take 2 or 3 years easily from start to finish, whereas arbitration cases, statistically, it's about a year. So it's a quicker process. It's a less expensive process, usually, and it has gotten more fair. and it's an expedited process, and there's no appeals. So it's come a long way since the 1980s. And back in the 80s, you had no ability to pick your arbitrators. You just got with whoever they assigned,
Right.
and you had no ability to even look at their previous decisions. There was no repository. There was no library, if you will. You didn't even know what their prior histories were. There was no way of knowing.
Right.
Now it's more transparent. You generally have a better idea of who you're getting, and hopefully it's fair on both sides.
Well, Tim, no doubt today our conversation has sparked interest by and from a variety of town residents who will have many questions as they move forward. How would somebody get a hold of you if they wanted to share some of their comments and concerns with you?
Well, they could email me.
Okay, how would they do that?
tjo@tjolaw.com.
All right.
Or they could call me at my office, 426-7700.
And your office is right down Ward's Lane, isn't it?
I maintain offices. My offices are located in a converted mansion. It's a 100-year-old mansion at 29 Ward's Lane in Manans, which is in the town of Colonie. It's in your jurisdiction, Judge.
Absolutely.
And we've converted this old mansion. There's 6 or 7 professional offices within the mansion. My office happens to be in the master bedroom. And so right here in the town of Colonie, that's how you get a hold of me.
Well, Tim, you've done so much groundbreaking work in this field over the past 30-plus years, and you've had a chance to help so many residents in the capital region who have been otherwise wronged in a financial transaction.
Yeah, it's one thing I did mention to you. Didn't want to mention is I maintain a website as well. And my website is stockbrokerlaw.com, STOCKBROKER law.com, stockbrokerlaw.com. If you log on, you'll see we have a number of consumer-friendly pages that answer a lot of frequently asked questions.
Great.
And we have various buttons or click-ons, if you will, whatever you call it, where you can click on different product areas, because we have different product areas that we represent investors in. I'm also presently involved in a class action involving an insurance product. And I also have a weekly blog where I try to keep the public apprised of developments in the areas of investor rights, securities fraud, and insurance fraud.
Well, you continue to practice on the cutting edge of this particular body of law. And not only that, though, you do have a life outside of that, and I know that you're a very accomplished distance runner. In fact, I saw you at the finish line back at a race last November, the Stockade-a-thon, which I think is a 15K.
That's a 15K race.
And you handled that with aplomb, and you continue to run. What's your next race? Do you have one set?
I've got one coming up the Del Mar Dash, but I think the last race I saw you and you beat me, I think it was Law Day at Washington Park in Albany, and I think you beat me.
Well, that was many moons ago.
You beat me, Judge.
Many
so, you know,
well, you were probably running a customer race where you didn't want to beat everybody that time.
you were way ahead of me. I know that for sure.
I've certainly slowed up as time goes on, but I certainly enjoy it, and I know you continue to succeed in that environment, and it's a great way to get exercise and be with a lot of other fun people who do the same thing.
Or take a hike in the Adirondacks as well. That's fun.
Yeah, that's right. I haven't climbed Mount Marcy in about 40 years. I still think I could do that.
You could do it. You could do it.
Up and down in a day.
Bring a canteen.
Got to do.
Yeah.
In my trail mix. Yeah. Timothy J. O'Connor,
Judge,
attorney
God
at
bless.
law. We're
Thank you
thrilled
for having
to have
me.
you.
Appreciate it. Appreciate your time and patience.
Thank you very much for joining us. And thank you for joining us on Benchmark.